let's talk about Mr. Novak's conduct as you understand it. This case involved a criminal charge and prosecution under Revised Code 2909.04, disrupting public service statute, correct?
Division B of that statute.
Division B of that statute.
Correct.
And that relates to public safety, right? Police and fire.
Police and fire.
And Mr. Novak was charged specifically under Division B with disrupting public services under the statute, correct?
Can you say that one more time?
Mr. Novak was charged for disrupting public services under the statute, correct?
Yes.
And to your understanding, what was Mr. Novak's conduct that was supposedly disrupting police services?
To my understanding, the creation of the fake Facebook page in and of itself, which looked nearly identical to the actual Parma Police Department's real Facebook page, caused a response of people who saw it, believed it was real, or at least questioned the believability of it or the validity of it, and called the communications center, interrupting the call takers who were there to answer legitimate calls for emergencies and non-emergencies.
So assuming all of that is true, though, you'd agree that it was just his speech on the Facebook page about the Parma Police Department that would have caused that, correct?
The content, in the context of what it was put on, like I said, on a page that looked nearly identical to the Parma Police Department's page, that's what caused the response, caused people to call the communications center and cause the interruption at the communications center, which is what the statute calls for.
All of that being speech, correct?
Yes.
And all of that being expression, correct?
Yes.
Now, there was no other action by Mr. Novak, I think, that we've established, right? There was no hacking of any Parma Police Department Facebook page or other computer services, correct?
Correct.
And there was no cutting of wires, correct?
Correct.
There was no destroying Parma Police Department computers or cell phones, correct?
Correct.
And Mr. Novak himself didn't engage in any conduct other than creating that joke Facebook page and writing Facebook posts on it, correct?
That I'm aware of, yes.
And that's just speech, correct?
Yes.
Now, you've read 2909.04B, the disruption statute under which Mr. Novak was charged, right?
Yes.
And you know that there is an intent element there, right?
Yes.
And are you aware of any evidence that Mr. Novak knowingly induced anyone to call dispatch?
No.
So this confusion you're talking about by some people, that was the disruption?
No, the disruption were the phone calls that were received at the Parma Police Dispatch Center, the Parma Law Department, the Parma Safety Department.
And you had no evidence at that time, as of March 2nd or March 3rd, that Mr. Novak had intended that result, correct?
Whether he intended it or not, it's reasonably foreseeable that people are going to be calling when they're confused and they don't know if a post that purports to be the actual page of the Parma Police Department is genuine.
How long have you been law director now?
I'm 21 years and 5 months.
Before that, were you an assistant law director?
I was an assistant law director in the city of Parma for 1 year.
And then have you also been an assistant prosecutor before that?
Let me restate that. I was an assistant prosecutor for the city of Parma for 1 year prior to my role as law director. And then prior to that, I was an assistant county prosecutor, pardon me.
For how many years?
For approximately 11 years.
So in all that time in dealing with Parma police officers, at least, who enforce criminal laws, you'd expect them to understand something as foundational as a reasonable person standard, right?
Sure.
Not a standard that only lawyers can understand, correct?
I agree.
And in fact, Ohio's criminal laws often require officers to apply a reasonable person standard, correct?
Yes.
August 12, 2016, in the middle of the first page of Plaintiff's Exhibit 20.
I see that.
An August 12, 2016 email. Right?
Yes.
Okay. So could you please read Prosecutor McGinty's email? Just you can skip the to part and just go right to the content.
Okay, so starting with thanks, Anna. Is that what you're asking?
Correct.
Okay. Thanks, Anna. I knew it would be a very difficult case to convince a jury. I am proud of you and all of the effort you put into this assignment. Taking this case to trial was the absolute right thing to do. No second thoughts. If he does it again, we will charge this bum again. His conduct was both outrageous and criminal. Tim.
Okay. So what did you make of the reference to Mr. Novak as a bum by the elected county prosecutor of the county?
What did I make of the reference? That's his characterization.
Did you agree with it, that Mr. Novak is a bum?
No, I would not agree with that.
And Mr. McGinty's email is in response to an email from Assistant Prosecutor Anna Woods reporting on the not guilty verdict. See that?
I do.
And she commented that the jury found it's a detective's job and a dispatcher's job to take calls and investigate. You see that?
I do.
Now, what did you make of that report?
I've done this before. I've prosecuted in the county before, and I always respect the verdict of a jury.
All right. So, actually, let's take one last question on this. Now, Mr. McGinty refers to Mr. Novak as a bum, but he says, if he does it again, we will charge this bum again. You see that?
If he does it again, we will charge this bum again. Yes.
And that is, can we reasonably infer that that is a reference to Mr. Novak? If he engages in similar conduct again, then the office would charge him again, right?
Well, I'd rather not speculate on what the county prosecutor meant by that statement.
Well, how do you take it? If he does it again, how do you understand that?
Objection.
Answer.
Yeah.
Oh, I'm sorry. So
The he is a reference to Mr. Novak, right?
I believe so, yes.
Okay. So how do you understand the import of that sentence?
I read it that the county prosecutor thought that it was a legitimate prosecution, but it came up short.
What effect, in your view, would a statement like that have on just a ordinary person?
Objection.
What like that from a prosecutor, in your experience as a prosecutor?
These are heat of the battle comments.
Yeah, that wasn't my question. The question is about the effect on someone like Mr. Novak reading a comment like that.
Objection.
And I don't know. I don't know the answer to that.
It's section 2909.04B, disrupting public service.
Yes.
Now, beyond that initial charge, carrying out the full prosecution under that statute is not within your jurisdiction as the prosecuting attorney for the city of Parma, correct?
Correct.
after his investigative report was completed, there were conversations I had with him that he was going to be going with Mr. Novak down to the Cuyahoga County Prosecutor's Office and meeting with County Prosecutor at the time, Tim McGinney, about the case.
So they were going to actually be meeting with Tim McGinty himself?
I believe they did.
Okay. Do you have any idea why this Facebook page merited attention from the top prosecutor?
I have no idea.
Was that, did you have any information about whether that was a meeting arranged by Director Debock?
I have no idea. No information on that other than just Connor telling me that they were going to be meeting with him about this.
And did Detective Connor discuss with you what transpired at that meeting?
I can't recall specifically if he gave me any details other than that they were meeting.
What about generally?
That the Cuyahoga County Prosecutor's Office believed that there was a violation of the Disrupting Public Services statute and the case was going to be presented to a grand jury.
And you?
Correct.
Yes.
Now, you had a meeting with the elected Cuyahoga County Prosecutor, Tim McGinty, about this case, correct?
Correct.
About Mr. Novak.
Yes.
Was it more than one?
No.
Were there telephone calls too?
No.
Were there calls made by you or someone in your office to set up the meeting with McGinty?
No.
How did the meeting get set up?
To the best of my recollection, I got a call from Detective Connor saying that the county prosecutor's office wanted to meet with me and him, mostly because the criminal defense attorney that was handling the plaintiff's criminal defense had filed either a subpoena or a motion for my personnel record. And so we were called down to meet at the county prosecutor's office on that.
Who was present in that meeting?
I was present. Detective Tom Connor was present. Prosecutor Anna Woods was present. County Prosecutor Tim McGinty was present. And I don't know if there was anyone else beyond that.
And again, you say that the prosecutor's office requested the meeting?
Yeah, the message came to me via Detective Connor, who said that they want me down too.
How was it scheduled?
It was scheduled to come down this afternoon.
Oh, same day?
Same day.
So what happened at the meeting?
There was a discussion about the case. There was a discussion about, I believe there was a motion to dismiss that was discussed. And then there was the brief discussion about my personnel record.
So let's start with the discussion about the case. You said what about that?
That was really Prosecutor Woods talking to Prosecutor McGinty about the case. And I don't have any specific things that I can relay to you about it.
What about the second component you mentioned?
The second one had to do with the motion to dismiss, and again, just some legal arguments concerning the motion to dismiss that was filed.
And what about the last component you mentioned?
Last component was about my personnel record, and we indicated that we'd file a motion to compel. And so I went back to my office the next day.
Do you mean a motion to quash? I'm sorry to interrupt.
That's okay, go ahead.
Did you mean a motion to quash?
Oh, I'm sorry, what did I say?
You said motion to compel.
Oh, sorry. Yeah, no, I meant a motion to quash. Thank you.
Okay.
And we indicated that we would file a motion to quash, and I was going to do that the next day in my office, and we did actually start a motion, but then we're told that either the subpoena or the motion was withdrawn, so we never did file that.
Now, the discussion about the motion to dismiss, you understood that motion to dismiss surrounded, at least in part, the First Amendment, correct?
Correct.
And so what was discussed in the meeting about that argument?
I don't recall the discussion about the the argument other than that it was being responded to, or it may have been responded to. I don't even know.
What did Detective Connor say in the meeting?
I can't tell you anything that anybody said. I know most of the discussion was Prosecutor Woods and Mr. McGinty. I don't have any recollection of anything else that was stated by anybody at the meeting. I really don't have any recollection about anything that was specifically said.
Okay.
I don't know. I don't recall.
Well, how long was this meeting?
It was about an hour, maybe less.
Did you and Detective Connor drive down there together?
No.
Or you arrived separately?
My recollection was he was down there. He may have had a grand jury presentation on something else, but I remember he was down there, so I just drove separate.
Okay. And your information about the purpose of the meeting came only from Detective Connor?
Yes. I don't recall.
Would you agree that Mr. Novak himself didn't make any calls to the communications center?
I would agree with that.
Did he personally take any actions other than speaking through the page that were the basis of his disrupting charge?
Not that I'm aware of personally.
And you were present for Detective Connor's deposition, in which he testified under oath that by the end of March 2nd, he knew that Mr. Novak's page was a joke, correct?
Yes.
And when you read his affidavit, starting with the March 3rd affidavit, Exhibit 5, working your way through Exhibit 7 and 8, those other affidavits, at each point, you too knew that Mr. Novak's page was a joke, correct?
We'll differ on the word joke. I'll say prank. But we knew that, I read it, he read it. We knew that they were untrue.
You already went over each of those 6 posts, read them in their entirety into the record, and gave your sworn testimony that reading them fully in their context as to each one and collectively, that a reasonable reader wouldn't believe they state actual facts, correct?
Correct.
So why not expect our Parma police officer to provide that same level of specificity to judicial officers so that a reasonable judicial officer can reach that conclusion?
So the analysis that you had me go through with respect to the reasonable reader test was today. I'm telling you, we did not consider this to be a First Amendment case back in 2016. We looked at it as a disruption case, disrupting public services. We didn't do your First Amendment analysis from the reasonable reader test. That didn't cross our minds at that time.
Right. And you understand that the Sixth Circuit Court of Appeals, citing case law from the U.S. Supreme Court, has said that in 2016, the law of parity was clearly established law and the reasonable reader test was clearly established law. You know that, right?
I do know that from the Hustler case, but I'm telling you that this didn't appear to be legal parity when there were active measures to continue the confusion.
And you also understand from the Sixth Circuit opinion that the Sixth Circuit said there is no problem with that. Your counsel for the defendants made that argument and it was rejected by the Sixth Circuit, the idea of extending the joke. You understand that, right?
Mr. Chandra, I could tell you're a good lawyer and you're a clever lawyer. Of course you were going to say that you were going to have your client come in with some reason of why he was doing it, and extending the joke is what you did. I understand that. But we didn't look at it that way. We looked at it that he was extending the confusion. He was purporting to make this page, phony page, a genuine page, and perpetuating the confusion to the public.
Through speech, correct?
Through what he did, through the banner, through the replicating Detective Riley's warning to the public, and by really, casting doubt on a very important governmental function that the Parma Police has of letting people know things that are going on from a safety standpoint in the city, and severing the confidence that the public has in that.
I return you to my question. Through speech, correct?
Objection.
It's through what he did.
Through which was speech and expression, correct?
I don't agree with that.
Tell me what conduct other than speech and expression he engaged in.
Objection asked and answered.
Go ahead, please.
The same things that I told you, that he put a site together that replicated the Parma Police Department site almost identically. Only an expert in Facebook would know the nuances on that. He also continued throughout the course of the day to take posts off of people who were trying to say that it was a phony site. He also replicated Detective Captain Riley's banner to warn people that there was a fake site, put the exact site up there, and impersonated that his was the real site and ours was the fake site.
And so I return you to the question, and all of that was speech and expression, correct?
Asked this 5 times.
And I'm going to stick with my answer that it's what he did. You characterize it the way you like to. It's what he did.
So you don't want to answer that question, but that was speech and expression, correct?
I did answer it.
Yes or no? Was it speech and expression?
I'm telling you, it's what he did. It's not a yes or no question. I went through it multiple times. It's what he did.
And what he did was speech and expression, correct?
Objection asked and answered 7 times now.
It's a yes or no question, Director. Can you answer it?
I answered it for you. It's what he did.
You're going in circles. I'm asking you to answer, is the what he did speech and expression? Yes or no?
Suppose you've asked him this 8 times. Both of you are getting frustrated. Why don't we take 20 seconds and take a breath?
I'd like an answer to the question, Director.
I mean, he's answered your question 8 times. If you don't like it, you don't get to answer it again.
It's a yes or no question, Director. You've listed off the things you say he did, and I've asked you whether those are speech and expression. If you disagree, just say incorrect.
Incorrect.
Okay. Thank you.
Is 5:20?
All right. Director, who is Jeff Crossman? Jeffcrossman?
Mr. Crossman is presently a state representative for the city of Parma and a couple other communities, but in 2016 he was a city council member in the city of Parma.
And that was true in March through August of 2016, the events of this case?
Yes.
Now, is he also an attorney?
He is. I do.
I'd like to. All right.
So I actually thought it was privileged because it was conversations between me and city councilman and the safety director. But whether that's produced or not, it's okay. And it says Director Debock. I have obviously not seen the evidence that resulted in the felony charge, but I am curious how confident the administration is in pursuing the felony case against Mr. Novak for creating a fake Parma PD Facebook page and what the civil ramifications might be. I did some research today and discovered that the city of Peoria, Illinois, paid a resident $125,000 to settle a civil rights claim brought by the ACLU under similar circumstances. The ACLU brought the case on a resident's behalf following the resident's arrest related for creating a fake mayor Twitter account. Obviously, the facts will be different, but there is certainly precedent about using social media for parody, and, as the Twitter case illustrates, parody is protected speech. Council will no doubt have 2 concerns. One, whether residents will view this prosecution as an appropriate use of safety forces, and 2, whether the city is incurring civil liability as a result of this action. Here are the links to the story. There are 2 links given. Then the last paragraph is, I have copied the chairs of Council Safety and Governmental Operations Committee, as I presume they will want to know as well.
So, excuse me, your response is Tuesday, March 29th at 9:02 p.m., so it's later that evening, right?
Correct.
Go ahead.
To Jeff Crossman, CC, Debbie Lime, Andreas Brocchetti. Andreas is A-N-D-R-E-A apostrophe S, Brocchetti, B-R-O-C-H-E-T-T-I, and Michael O'Malley. Subject, Ray, Facebook felony charge. Councilmen, the accused was charged in Parma, but the case will be presented to a county grand jury. The grand jury will determine whether to indict. I think we need to wait and allow the grand jury to act. I have asked the detective to turn over the evidence to me for review. Thank you for the information on the case from Illinois. We will look into that case and law further. At least initially, I would observe that the Illinois case was clearly satire, and in fact, the Twitter account was so labeled prior to the search warrant. Here, there was no disclaimer that it was parody, and on at least 2 occasions, the defendant responded to a blogger that this phony site was in fact genuine. Frankly, it was the plain dealer that characterized the site as a parody site. I disagree with that characterization. At least one of the stories created by the defendant purported to claim that the Parma police were hiring, and that a civil service test was required, and that, quote, minorities need not apply, unquote. For a community that has for decades battled an unfair reputation of being racially insensitive, this is destructive misinformation. In addition, the city and the police fielded several calls from people complaining about the site. The police department had to contact Facebook to have the site taken down, and the public information officer of the PD had to issue a press release to advise the public of the phony site. In my view, I believe the police have acted reasonably. I will review the evidence from the investigating detective and advise accordingly. Thank you, Tim.
Okay. This attorney and city council person, Jeff Crossman, was specifically raising the fact that parody is protected free speech, correct?
He did.
And he was raising with you the specter of potential civil liability for the city, correct?
He did.
And you testified earlier that you had not considered that as part of your legal analysis in advising Detective Connor. You recall that testimony?
I do.
So was this on March 29th, 2016, the very first time you had ever considered that issue?
I would say yes.
But there were also communications from other people raising the same issue even before that, right?
It was right around that same time.
All right, we'll come back to that. But let me focus you back again on Mr. Crossman. He had done some research and brought a case from Peoria, Illinois to your attention, correct?
Correct.
And your response was that you would look into the case from Peoria, Illinois, correct?
Correct.
And in your response, you said you thought the Illinois case was distinguishable because there was a disclaimer that it was satire, right?
I did say that.
Now, where did you get the idea that the law requires satire or parody to be accompanied by a disclaimer label?
Well, I don't know where I got it. I do know that, like in the Hustler case, for instance, it was labeled as parody twice. So I don't know where I got that point, but I don't know that I would have gone the step further and say that it had to be. I don't think that it does have to be.
But you specifically represented to this Councilman Crossman that you thought that the Peoria case was distinguishable, meaning you didn't think it applied, because in that case there was a disclaimer, right?
That was one of the reasons.
Okay, but that, again, that was one of the reasons. But
Yeah.
again, I've asked you earlier, you've read the Sixth Circuit opinion in this very case on the issue of qualified immunity, right?
Yes, you did.
And in that case, it's Plaintiff's Exhibit 40. Can you take a look at it, please?
Okay.
If you look at it, on page 4, the Sixth Circuit cited to a United States Supreme Court case called Campbell v. Acuff Rose Music, Inc. That's ACUFF-Rose, R-O-S-E, Music, Inc. And that's a Supreme Court case from 1994. Do you see it?
I do.
And the Supreme Court case quoted that case saying, quote, "Parity serves its goals, whether labeled or not, and there is no reason to require parity to state the obvious or even the reasonably perceived," unquote. You see that quote?
I do.
Now take a look at Plaintiff's Exhibit 58. That's a copy of the Campbell case. And we might, if we have some time, go over that a little bit more later.
Okay.
Did you look at this case or even look for it when opining to Mr. Crossman that the Peoria case was distinguishable because the satire was labeled?
I did not look at this case prior to that.
Had you ever heard of it?
I hadn't. I heard of it from the Sixth Circuit opinion. It was the
Even though it had been around since 1994.
correct.
And so can we agree that when you stated to Mr. Crossman that the Peoria case was distinguishable because the Peoria case labeled itself as satire, can we agree that that point that you made has no legal significance?
One of the distinguishing points that I had on the case, and I agree that parity does not have to be labeled as such.
In 2016, is it fair to say that you overlooked that United States Supreme Court case of Campbell v. Acuff Rose Music when making decisions about what to do regarding Mr. Novak?
I was not aware of it.
Okay. Is it fair to say you overlooked it?
No, I'm just saying I wasn't aware of that case.
Now, and you didn't feel the need before opining to Mr. Crossman to actually research whether the fact of a label has any legal significance or not. Fair to say?
I did not research that point before I responded to Mr. Crossman.
And you didn't think it was important to do so either, did you?
No, I looked at the case and drew my distinguishing points from the case, but I did not research the Campbell case.
Well, what you did was point out a factual distinction, but you didn't try to figure out whether that factual distinction had any legal significance, fair to say, correct?
I did point out a factual distinction.
And you did not try to determine whether that factual distinction had any legal significance, correct?
Again, I wasn't looking at it as a parody or a satire or a First Amendment case. I looked at it as a violation of a statute.
Well, let's go back and look at your email response to Mr. Crossman, Exhibit 49. You said about Mr. Novak's post about employment, quote, why don't you read it with the words "for a community"? Read those words, that sentence.
For a community that has for decades battled an unfair reputation of being racially insensitive, this is destructive information.
So the content of Mr. Novak's speech did matter to you in deciding whether to pursue this prosecution, correct?
It didn't matter it mattered to me to put it in the letter to the councilman. It didn't matter to me with respect to the charge.
Well, why was it important to mention to the council?
I don't know how much in the way of facts the council had on this.
Why was that fact significant? Why? Let me rephrase. Why was the content of Mr. Novak's speech and its effect on a community that has for decades battled what you called an unfair reputation of being racially insensitive, why did that matter at all in what you were telling the council?
It mattered for me to tell the councilman one of the posts, but as I'm telling you, it didn't matter to me with respect to the violation of the statute, because that was just, we were basing it on the disruption.
If you could please take a look at the way that paragraph begins. That's a fresh standing paragraph. And it begins, frankly, it was the plain dealer that characterized the site as a parody site, right?
Correct.
And then you say, I disagree with that characterization, right?
Correct.
At least one of the stories created by the defendant purported to claim that the Parma police were hiring and that a civil service test was required and that minorities need not apply. Did I read that correctly?
You did.
Now, then you conclude that paragraph, for a community that has for decades battled an unfair reputation of being racially insensitive, this is destructive misinformation. And then the paragraph goes on to talk about the calls that were being fielded. Up through that point, are you arguing the point of whether or not Mr. Novak's page was a parody or not?
Am I arguing the point that whether it was parody?
Right. Are you making an argument about whether the page was parody in that sentence?
I'm not making an argument that it was parody.
Okay. So what, I'm still not sure I understand the answer to the question, sir. Why are you focused on the unfairness of Mr. Novak's post?
This is a different audience. This audience is to the city council, not necessarily part of the information that I was giving to the police department for their follow through in this investigation. So I really think that this was a different audience, and I wanted them to know some of the things that were being stated.
And you also said that it was destructive misinformation, correct?
I did.
And you were trying to justify the charge to the council, correct?
No, I don't have to justify the charge of the council. The charge has to be justified to a magistrate or a judicial officer.
Well, that wasn't my question about whether you have to justify it to the council or not. I'm trying to understand the reason you put this sentence in there. And what I'm hearing is that you needed to say it to council, but I don't understand why they need to hear it.
They questioned me. They questioned me, so I gave them my response to his email.
Fair to infer from this that the content of Mr. Novak's speech was, in your view, unfair?
No.
Is it fair to infer from this that, in your view, the content of Mr. Novak's speech was, quote, destructive misinformation, unquote?
I will say that I stated that in my letter, that it was destructive misinformation. But again, it's a different audience. I'm explaining this to city council. I'm not, it's not part of the investigation.
Director, respectfully, that wasn't my question. So I'm going to ask the court reporter to read you my particular question and ask you to answer that question.
Now, you're familiar with the interference with civil rights criminal statute, revised code 2921.45. You ever seen that?
I've never read it through, but I am familiar that it exists.
And it's a statute that makes it a crime in Ohio to interfere, for government officials to interfere with constitutional or statutory rights.
I've not read it, but that's what you say it is. I would have no reason to doubt that.
So you have no reason to doubt that it's a crime in Ohio to interfere with First Amendment protected activity, correct?
Objection. You can answer if you can.
I've not read the statute. Mr. Chandra, I don't know for sure.
Well,
Never heard of it till now, till you
Okay.
just told me.
all right. And you didn't try to Google it at all, even after receiving this email. What's the EFF?
That's correct.
And even the assertion that Hustler Magazine v. Jerry Falwell determined that parody is absolutely protected speech didn't even set off any alarm bells for you?
Mr. Chandra, this case wasn't based on just Mr. Novak's parody or the page. It was based on the result of the page, which was the interruption caused at the communications center. It wasn't based just on the speech.
Have you heard of a First Amendment concept? Let me withdraw that. Have you received any training about a First Amendment concept known as the heckler's veto?
No, I haven't.
And that is the concept, I'm going to spell it out for you to see if this refreshes your recollection. That's the notion that just because some third party gets irritated and doesn't like the speech doesn't mean that the police or the government have the right to try to quash that speech?
Okay. I've
Okay.
never heard of it.
Okay, so you've received no training on that at all, and certainly not before March 2016, right?
That's correct.
So at the time, you were considering the reputational issues of the Parma Police Department, correct?
No.
That's what you said here, isn't it?
No, it's not what I said here. Here's what I'm going to tell you. I wear two different hats. I'm a prosecutor and I'm a city law director. The city law director will defend suits, including discrimination suits that we've done over the decades. So I'm writing to him really as the law director, not the prosecutor. Prosecutor gives advice to the police. So like I said, it's a different audience that I'm writing to. I believe, well, I'm going to finish my sentence here. Did I believe it was misinformation as a law director? Yeah, I do believe that that's destructive misinformation.
Okay. He's writing you to justify the criminal charge, isn't he?
Yes.
Okay. And you had been involved in that, correct?
Yes.
Okay. And okay, to the extent that you perceived you were writing back with a different hat, and I've been a law director, I understand what you're talking about. So to the extent that you perceive you were writing back with a different hat, either way, the same First Amendment to the Constitution applies that you're discussing with either hat on, correct?
Yes, the same
Right.
First Amendment concerns are there. Yep.
Right. So whether you're talking about the First Amendment as a defense to the criminal charge and why the charge shouldn't exist with your prosecutor hat on, or whether you're addressing the potential issue of civil liability to the council with your law director hat on, either way, we're talking about the same First Amendment containing the same free speech clause, correct?
Correct.
And so you said in your quote to Mr. Crossman, for a community that has for decades battled an unfair reputation of being racially insensitive, this is destructive misinformation. That is what you said. And my question was, you were focused on reputational issues for the Parma Police Department, correct?
Reputational issues for the city, not just the Parma Police Department.
Okay, broader. You were concerned about reputational issues for the city of Parma, which includes its police department, correct?
Correct.
And so you were concerned about the potential reputational harm to the city of Parma, including its police department, when you were justifying to a city council person why the charges were appropriate, correct? That is the context of your response, correct?
No, I don't agree with any context that you characterized. I'll tell you, I'll ask you to have that repeated. It was a very long question, Mr. Chandra, and it's very late, so I want it repeated. Okay, dear Lieutenant Riley, comma, if you wish to violate the Constitution and make the Parma police actions seem like those of the FSB and police in Russian, then you should attack to prosecute Anthony Novak for ridiculing the Parma Police Department. You'll have to go pretty damn far to demonstrate that Novak endangered public safety. This is clearly an effort to shut down criticism. Did the policy department learn how to police at Putin Police Academy? Grow some thick skin, roll with the punches, laugh, make fun of Novak in a satirical Facebook page, but don't be asses. Sincerely, Paul.
Now, this one was on March 27th before the final affidavits, correct?
Final affidavit was the 28th, I believe, correct?
Correct.
So yes.
All right. So, again, you saw this at some point before Mr. Novak was tried. What did you do with this?
I didn't do anything with it.
Did you?
I mean, I recognize that it's criticism of the police and me, and I understand that that's protected, and so.
Did you try to do any research?
At this point, it was downtown. I did not do any research of that.
Now, you were aware that even on the City of Parma's own Facebook page, there were people in just the days after Mr. Novak was arrested who were posting citations to Hustler v. Falwell, who were posting other First Amendment cases, who were complaining about First Amendment issues, correct?
I don't know that.
So did Detective Connor never tell you that?
Are you talking about the police Facebook page or the city's Facebook page?
I'm talking about the police Facebook page.
Oh, yeah, I knew there were comments on the police Facebook page.
And you were aware that there were citations to Hustler v. Falwell on that page by members of the public, correct?
It wouldn't surprise me. I don't know specifically if I saw Hustler cited there.
Well, you still didn't go look at it, though, right, at that point?
I did not.
Why not?
People could they could post what they want to on those pages. That's fair game.
Of course they can. I'm not suggesting that, Director. I'm asking you why you wouldn't take that as a cue to maybe look into what they're trying to communicate to their government.
The case had moved on from my purview.
No, not at that point. You were still approving warrants.
Second.
So
I do have
on
a
March
concern.
2nd, you were worried about the citizenry storming the police department in response to Mr. Novak's post.
I had concerns that there were some people that were going to be angry about the thoughts that we were going to be arresting people for feeding the homeless. Yes.
You didn't see one comment on March 2nd of anybody threatening that they were going to come down to the police department and do anything, correct?
I did not.
Nor did you see any threats that anybody was going to show up at the Giant Eagle where police are supposedly performing abortions or going to be performing abortions on teens in a van, right?
That's correct.
Indeed, the Post said that that event was going to be a month and a half later in April, correct?
That's correct.
So you had plenty of time to pause, reflect, and figure out whether you needed to deploy a battalion of officers down to the Giant Eagle parking lot to protect against this non-existent threat, correct? correct?
I never deployed a battalion of officers to the
Like
Giant Eagle.
you didn't even have to think about planning for that because it was a month and a half off, right?
Well, I mean, at the time, I mean, yeah, but the date was far off. But you're asking me about March 2nd, and I'm giving you my perception and my recollection to the best of my ability of what thoughts were in my head on that day.
And on March 2nd, you saw that the supposed teen abortion event in the Giant Eagle parking lot with a police van. First of all, there's no police van there on March 2nd, right?
I agree with you.
And even if that post were true or to be believed by any Yahoo, as opposed to a reasonable reader, it's not going to happen until April anyway, right?
I mean, you presume that, but you don't know that.
Well, you mean the fake post was faking about the actual day of the teen abortion event? Okay,
You're
so
missing
given
it.
that thought process on March 2nd, tell me if this is a fair summary of your sworn testimony. On March 2nd, you thought that there was a sufficiently imminent threat or risk of a public safety hazard at the Giant Eagle parking lot that you felt that shutting down Mr. Novak's speech on his Facebook page was justified. Is that a fair summary?
No, it's not.
Okay.
I didn't use the word sufficiently imminent. I never said that. I said it was just a thought in my head. It was
Okay.
discussed.
Then let's correct that. On March 2nd, you felt that there was a sufficient risk of some sort of serious violent disturbance in the Giant Eagle parking lot that you thought that shutting down Mr. Novak's Facebook page was justified. Fair enough?
I wouldn't classify it even as a sufficient risk. I would just say it was at least it was a thought in my head that it's a remote possibility, however remote. I mean, I don't know, because I don't know who's going to read that on the other end and see that.
So on March 2nd, you thought it was a remote possibility.
Yes.
So you didn't say that it was a remote possibility in Mr. Novak's criminal trial, did you?
I don't believe I used the words remote possibility.
You didn't even use words that would suggest the thought of a remote possibility, did you?
No.
That's new today.
You're asking me to give you my thoughts that day. If you're talking about, I think I know what you're talking about, but I didn't use those words.
Or anything suggesting that concept, correct?
The defense attorney used the words. I agreed with him.
He said that they got the records back from Facebook pursuant to the subpoena, and that we went through the comments under that. And in fact, the comments, especially with respect to the homeless post, were extensive. In fact, I was looking through them before, and I went through Defendant's Exhibit 2 from the Novak deposition, and we looked through these, and then I highlighted just a sampling of them from page 48 of the Facebook records to page, just 20 pages, like 62. And there were dozens of comments of people that were misled and thought that this was a believable page. There's one from Zach Hosier from the 2nd that says, "When I am home on leave from serving this beautiful nation, I will make it my #1 priority to feed the homeless in front of one of your police stations." There is another one on the next page on 49 from Sabrina Weber. The homeless are people, not rodents. Caught giving the homeless food, etc. This sounds like Parma has some kind of pest problem. The homeless are not any less of people than anyone else in this city. Another one from Mike Ryan, "You gotta be shitting me." Another one from Alan Schreiner, or you could extend your services and give aid to those who need it, you lazy Fs. Another one from Rob Moses, "And people wonder why I break the law. F you, Parma, and F your shitty ass police officers, F your judges, and F everything else that swings along with your pissy ass guidelines. I'll do the 90 days in your petty ass jail, standing on my fingers. But truth be told, it takes you brainless piss ants more than 90 days to even catch me." Another one from Donnie Cannon, "If this is Parma Police's actual Facebook page and this is a real post, I just want to say you're all a joke and this is sickening." There's That one continues on to the next page, which is page 50. It says, you're only looking for money and you're lazy bastards. Some of these homeless people have had no choice in this, and a majority of them actually do follow your so-called rules. Even though every single officer in your department is crooked or fat and lazy. Well, I won't say everyone, because I know a couple that actually do want our city to be safe. Here's an idea. How about us citizens get to ticket you guys for all the illegal shit you do, and what we make off the tickets we'll donate to the homeless. If we did that, we could earn enough in 3 days to stop homelessness in the county. Every single day I see a cop texting and driving, smoking in our city vehicles, sitting somewhere they're not supposed to. God, I didn't even want to touch the subject or post, but you lazy peas just pissed me off. See you on the 9th for court. Hope one of you had the balls to say something about this. Another one, Corey Michael Tegarty.
Slow down, because our court reporter is struggling to keep up.
Oh, so sorry.
Yeah.
Corey Michael Tegarty, Tegarty. Good thing I'm not a Parma resident. David Wagner, the city of Parma is a effing joke. Page 51, Tammy Andrews. You can't throw someone in jail for giving someone food. That is the most ridiculous thing I've heard. I think I may just go looking for the homeless in Parma, take them to a restaurant in Parma and feed them. If compassion lands me in jail, so be it. John Clem, same page 51. Wow, we can say this is ignorant here. What if your family was out there hungry and homeless? Now it's illegal, Ashley Schurer, S-C-H-E-R-E-R. Now it's legal to give the homeless people anything. That was on page 52. Eric Cody, you're a fascist pig because someone doesn't have a place to live or make food or have food makes the city look bad. How about you effing help out and raise money to donate some so you have a heart, you effing scum. Swear word. Vanessa Cecil, glad I moved out of Parma and I'm never coming back. It just keeps going down more and more. Said it used to be a beautiful place like 30 years ago. It's just sad. Michelle Pavlik, same page 52. WTF, are you kidding me? Page 53, Nick Capanzi. What an effed up town. Nadine Simmons, I can't believe the police department issued this statement. They had no other options other than threatening to put people in jail for helping out the less fortunate. WTF, I hope this isn't real, because if it is, it's very sad. So, I mean, we looked at those. We looked at those and we realized that there was real disruption, there was real confusion within the city. And again, when we met on the 18th, the purpose of that meeting was for an arrest warrant. And again, as part of the investigation, I advised that an arrest warrant could be sought. So I advised him that he could seek an arrest warrant from a magistrate.
You just used the word disruption. How did those posts disrupt public service?
The posts show the confusion, Mr. Chandra. The posts show the complete confusion that was going on the 2nd and 3rd. The disruption are the calls to the police station, to the law department, and to the safety department.
So some of these comments are people volunteering to help homeless people, correct?
Correct.
So you wanted to arrest Mr. Novak for inspiring people to want to feed the homeless?